we've heard enough of how on the ease of doing business index, India rated fairly low, much lower than what you would expect a country of this economic strength to rate. A lot of foreign investors were very wary of coming to India because they felt that you had too many bottlenecks, be it the bureaucratic bottlenecks, the legal regime took a lot of time, litigation was far-stretched, too many layers, nothing was time-bound. It was always a very promoter-driven process also. So in a lot of cases, we saw the investors didn't derive the ROI that they expected of it. Primarily if I can say, to dumb it down, what it essentially does is it allows for creditors such as, financial creditors, operational creditors, companies, guarantors, corporate debtors, individuals to sort of invoke the provisions of the code. When do you invoke it? When there is a debt and there is a default of that debt. The most common ones that we see as lawyers today are financial debts and operational debts. Financial debts are your time value debts, which you see, which is basically money lent to banks, NBFCs, etc. And the other one that we see are operational creditors. Operational creditors are those people who've lent you money against provision of goods and services. Could be, consultancies, could be giving goods, could be supplying raw material, etc., etc. These are the two most common type of creditors that we see. What's the forum for disputes or for issues arising out of the Insolvency Code is the National Company Law Tribunal. An appeal from that goes to the National Company Law Appellate Tribunal, and then in an SLP to the Supreme Court if and when. It's also important here that we've seen cases where the writ jurisdiction of courts have also been invoked. In some cases, courts have sent them back saying this is not the appropriate forum. In some cases, they have entertained it, but more so in a limited fashion to go and ask the NCLT to do things a certain way. So by and large, under this regime, you have a specialized forum hearing disputes, which by itself has sort of made things faster. You're not stuck in a tribunal which is overburdened in most cases, but you have a tribunal where there are benches which are by and large hearing matters under the code. So the code does give you an upper limit, extendable as well, but then people were still using the time spent in litigation to deduct from that time period, where the Supreme Court in SR Steels comes in and says, no, you can't do that. Even if you're litigating, the broader outer time limit is 330 days. A lot of people felt that when the Insolvency Code came in with the amendment of 330 days, it was draconian, it was not fair, because what if a company on the 325th day is close to resolving but needs, say, 15 days. So SRC qualifies it to say while you try and follow 330 days, that amount of flexibility remains. So the biggest thing this does is it puts in a time-bound system by which you need to get things moving. You cannot misuse the process. I keep coming back to misuse because that's been one of the biggest grievances of investors and lenders in the past. That you have a process which has multiple stakeholders. You have a time-bound mechanism. You have an NCLT which is continuously supervising the process, an NCLT which allows for a provision which lets you knock the doors of the NCLT if you feel anything about the CIRP is not going the way it does. So there's a lot of skin in the game. There's a lot of trust that's bestowed on all stakeholders.